In 1988, we filed a lawsuit and we raised basically two claims. One was that the state had created additional judgeships but had not submitted them for pre-clearance under Section 5 of the Voting Rights Act. They said they didn't have to do that. And then we had another claim in which we said that the method of electing these judges at large from judicial circuits violated Section 2 of the Voting Rights Act, which protects the equal right of minorities to elect candidates of their choice. Well, the litigation was very complex and the issues went up and down. On the Section 5 claim, we did get a decision from the Supreme Court that the adding judgeships was a voting change that was covered by Section 5 of the Voting Rights Act. But the voting changes were pre-cleared, meaning that the only claim we really had left was the Section 2 claim. At the time we filed the lawsuit, there were only 6 of 137 judges who were African American. And we knew that the state was divided into 45 judicial circuits, each containing between 1 and 8 counties, each electing between 1 and 14 Superior Court judges. We determined that if you went to single-member districts, that you could create a minimum of 25 majority black districts, meaning that the residents and voters in those districts could elect candidates of their choice, which would include African-American judges. So we claimed that the at-large system diluted Section 2 of the Voting Rights Act. Well, that issue sort of went up and down, and we met with Governor Zell Miller at the governor's mansion. I was at one of those meetings, and there is no question that the litigation had an enormous positive impact on the appointment of more African-American judges. However, while our case was pending, the Supreme Court had issued a ruling that Section 2 did apply to the method of electing judges, that you could bring a Section 2 claim challenging at-large elections for judges. However, there was a series of cases decided by the 11th Circuit. Georgia is in the 11th Circuit, which ruled that Section 2 did not apply to the method of electing judges. And the Supreme Court refused to review any of those cases. It wasn't just one case from the 11th Circuit. I think there were like 3 major cases in which the 11th Circuit said you could not have a Section 2 claim. So the Supreme Court refused to review any of those, so we know that we couldn't really proceed on our Section 2 claim because the courts would dismiss it. So that's where the Section 2 claim finally ended up. But as Tyrone points out, the litigation did have an enormous positive impact. And I will just close by saying that we're talking about judges, but the problem is more profound, infinitely more serious in Georgia and in the South. It was not just a selection of judges that was discriminatory, it was the entire judicial justice system. The prisons and jails were racially segregated. They didn't get desegregated until a lawsuit ultimately decided by the Supreme Court, Washington versus Lee, held that racially segregated prisons and jails in Alabama violated the Equal Protection Clause of the 14th Amendment. That was a very interesting case because the state of Alabama argued that the Equal Protection Clause as applied in Brown versus Board of Education, the school desegregation case, did not apply to prisons and jails because it said inmates, convicted felons, are not innocent school children, therefore equal protection doesn't apply. Fortunately, the 3-judge court which heard the case said that the 14th Amendment follows people into prison, and it invalidated the prison system. So we were subsequently able to use that decision to desegregate all the prisons and jails, road gangs, and so forth. So we had prisons and jails that were racially segregated. We also had grand and trial juries that were racially segregated. Right. Blacks were not chosen. So you had all white juries indicting a disproportionate number of blacks for offenses, and they were tried by trial jurors that were selected from all white lists. So there were a lot of habeas corpus actions filed on behalf of blacks who had been convicted and sentenced to death. All of those habeas corpus actions were successful. I don't think any of them were not successful. We also represented black men and women who were eligible to serve on juries but who had never been summoned. All of those lawsuits were successful. The states finally realized they could not indict and convict people using racially discriminatory juries. So the state of Georgia finally enacted a law which is on the books, which provides that juries in a given jurisdiction must be selected from a list that represents all the people who live in that jurisdiction. So if you go, I mean, I've been summoned to serve on juries in Fulton County, and I've been impressed with how racially diverse the people who show up are, and I'm sure that's the case throughout Georgia, but it was not always that way. Also, it was not just prisons and jails, it was not just juries, but it was law schools. Georgia didn't have a law school that blacks could attend until, fairly recently, I mean, a number of years ago. So you had a bar that was racially segregated, and even when there was a law school blacks could attend, you had a white bar association and a black bar association. That obviously has changed now. But, we live in a system that has always been, tainted with race. And unfortunately, we still see that in the selection of judges. That there simply are not a proportionate number of African Americans who serve on juries, and we need to remedy that. And I'm glad to see that that's what this conference is all about. It's a huge thing we need to do.